So we shall start our lecture with the pre-reading bar professional training course material that is available on internet as well. So bar professional training course is quite intensive and one needs to have some prerequisite information in order to deal with it. So this bar pre-readings of the bar professional training course includes introductory advocacy session materials, dress codes, legal research, civil litigation and evidence, criminal litigation, and professional ethics. I think we should go to the civil litigation part. So, these are the aims of the civil litigation. To get you the idea of contract law, introductory evidence, and basic civil procedure rules. So now we shall discuss what are the principles of contract law. The bar professional training course is that you have a basic knowledge and understanding of the contract law, specifically formation of contracts, formation of written contracts, generally principle concerning implied terms, misrepresentation, discharge, remedies for breach of contract. So, what are the contents of a contract? Introduction. The rights and remedies available to the parties to a contract depend on whether the damage they have suffered arise from a misrepresentation or a breach of contract. Furthermore, both misrepresentations and terms fall into different categories, each giving the part different rights and remedies. So, in contract law, you can take other party to the court for breach of contract or for misrepresentation, and both give you different kind of remedies. When a claim is brought before the court, it is the court that decides whether there has been a misrepresentation or breach of term. The court decides these matters by ascertaining the intentions of the parties, but the fact is that the parties respect a term in their contract and each condition or guarantee is not conclusive. So there are some pre-contractual statements, matter of fact representations, in terms of conditions of the contract. What are the warranties? These are the things that court shall see. Now we shall see what are the remedies of the contract. Firstly, there are damages. Damages are probably the most important remedy for breach of contract. They are known as common law remedy, and provided the claimant wins his or her case, the remedy is said to available as the right. In order to investigate the case in relation of quantum, it will be necessary to consider two separate issues. What heads of recoverable loss have been suffered in the present case? Like what kind of loss that is recoverable has been suffered? It shall be seen by the party. And how much can be awarded by the court? and court will also see that how much could be given to the party. Then there are like types of damages. There are special damages and there are general damages. Special damages are those items of financial loss which can be arithmetically quantified, and they are losses which accrue from date of cause of action up till the date of trial. So those damages which could be quantified, which can we find out how much damage is done, are the special damages, and in the case where you can't do this, those damages which you will get are the general damages. Then are the recoverable loss. The object of damages of breach of contract is the place injured parties in financial position that they would have been in if the contract has been properly performed. However, not all losses will be compensated. Damages are only recoverable for losses which are judged to reasonably foreseeable or not too remote. You can go through all of this. Not very important. So now what's important is the law of evidence introduction. You will recover more detail about the law relating to evidence as we go through the course. But you need to know about the introduction. There are 2 points that are there. The legal burden of proof. In civil cases, the party who asserts that a fact is true has the burden of proving that fact. If a party says that something is like this, so that person has to prove, that party has to prove that whether that thing is like this or not. Then there is the standard of proof. The fact must be proven on the balance of probabilities. Note how finely balanced this standard is. Very small differences in the weight of credibility of the evidence could be potentially important. The fact is 51% likely to be true compared to 19. Like there is little bit of difference in the cases, and which has more weightage that shall have more value. Now there is method of proving a fact. A fact alleged to be true must be proved by evidence. There are exceptions to this rule, and when exception applies, no evidence to be proved to the fact of alleged need to be adduced. The two most commonly encountered in civil dispute resolution are where a fact is formally admitted by the party against whom it is alleged, or where the fact is inferred. For example, if it is proved that a customer inspected goods, paid for them, took them away, and made no complaint, it may be possible to persuade the court to infer from these facts that the goods were of satisfactory quality. Then there are the types of evidence which can be adduced. There are oral evidence, written witness statements, written expert reports, documentary evidence, or real evidence. What is that you consider about the competence? A witness must be alleged competent to give evidence on oath or by affirmation. Note that the child may give unsworn evidence if he is possessed by sufficient intelligence to justify the reception of the evidence. So, a witness must be competent, and for that he has to give evidence on oath. Compellability. In civil proceedings, a witness is always compellable whenever their status or relationship to the party However, a relationship between a party and a witness may affect the credibility of the witness evidence and its weight. Documentary evidence. Under the Civil Evidence Act, either original or copied document can be used. If the authenticity of a document is challenged by an opponent, it will be necessary to articulate it in a manner approved by the court. Evidence of character. Previous conduct either of the party witness are generally not considered relevant to prove a fact. Like if you have done something wrong in previously, it is not considered as relevant. Such evidence may however be considered relevant, and it could be considered relevant to show the credibility. For the sake of thrashing the credibility, one could give the evidence of the character against a person. Opinion evidence. A witness gives opinion when he draws a conclusion from a set of facts. Such evidence is generally inadmissible in civil proceedings because the judge tasked to draw conclusions from the facts admitted and proved in evidence. There are two exceptions. Oral evidence has not given due weightage in the court of law, but there are expert evidence that is given due weightage, and there is privileged evidence like legal advice privilege and litigation privilege and without prejudice.